periodically try to put on a presentation or webinar regarding governing document amendments periodically. So if you've attended it in the past, you will see some similar concepts. We do try to update it. So we've got different things that are in this particular presentation that have not been addressed in the past. But from an overarching standpoint, the goal still is to try to provide an understanding of what it takes and what's involved in amending your governing documents, what the term governing documents really means for an association, and then give you some common problems that arise during that process. So that's what we have going on. If you have questions, please feel free, please drop them in the chat. It's probably easiest. I'll try to catch them as we go along. If I'm in the midst of something and I really have a good train of thought, I may wait to answer the question. You can also wait till the end if you want to ask any questions. I'll do my best to answer them once we get there. Basically, the way we divide it up is as you look at your governing documents, whether you're a homeowners association or whether you're a condominium, either one, you're basically at three types of amendments, three types of documents that can be amended.
My God.
And all right, and then if I mute you, it's not because I don't like you, it's just because I want to try and give allow everybody to be able to hear. If you want to be unmuted, just send a chat. And I think you still have the ability to do it on your own also. So there are basically three types of documents that we're looking at. We're looking at articles of incorporation. Your articles of incorporation need to be amended. Does your declaration, master deed, or bylaws, do they need to be amended? And then how do you adopt and enforce rules and regulations? Those are the three basic categories. You have your articles of incorporation, your declaration or master deed or bylaws, and your rules and regulations. You can, in theory, break out corporate bylaws from that middle category, which we'll get to in a little bit. But those are kind of, in broad strokes, the three categories of documents. Articles of incorporation you can usually do by a member vote. Declaration, master deed are a little bit more complicated. Sometimes you can do them by a vote. In a condominium setting, you need a supermajority. A declaration can be a little more complicated if you need lot owner signatures. And then what's really interesting is that rules and regulations can be amended in the absence of an oddity to a certain extent. Rules and regulations can usually be adopted by the board of directors themselves, although there are certain qualifications and limitations on what they can attend, or what they can do on their own. And then Beth, I know you just joined, we just got started, so you haven't really missed anything, but welcome. All right, so with respect to the typical amendment process, and I kind of touched on that, for your articles of incorporation, it's almost always a member vote. It's going to be there's a couple of tricky aspects to it. Usually it's going to be a majority of votes cast, but some documents require a percentage of the total members. And you just need to make sure to pay attention to what the amendment provision states. For the master deed and condo bylaws and subdivision plan, this is relative to a condominium governed by the Michigan Condominium Act. That's going to require, assuming it's a material change, an affirmative vote of 2/3 of all co-owners qualified to vote. Potentially going to be a number, potentially going to be by value, but basically 2/3 of the entire community must vote yes for that to vote. And then in many instances, you're going to have a mortgagee vote component of that also. The difference being that a mortgagee vote does not need to be the affirmative vote. As long as proper notice goes out, mortgage companies are assumed to have voted yes as long as they don't vote no. Declaration of covenants and restrictions is going to be, from a document standpoint, it's similar to a master deed in the sense that it's going to control what people do. But because it's a matter of contract, entirely a matter of contract, the method of amending it is going to be based upon what the original developer, original declarant put in those documents. Sometimes it requires a lot owner signatures. Sometimes it requires a majority. Sometimes it requires 2/3 or 75%. We've even seen some documents that can be amended by 1/3 of all lot owners. So it really depends on what was put in, and you do need to pay particular attention to the requirements of the vote, the requirements to amend the documents usually tucked in at the end. There are a couple little oddities, little things to keep in mind when you're looking at amending a declaration. And a declaration is going to be in a non-condo setting. This is where you have an HOA that's not in a condo. Some provisions have automatic renewal provisions, which would mean that you can only amend at particular times. And in a lot of instances, a declarant would put these in order to try to create periods of time where the documents must be the same and they cannot be changed. And some provisions or some declarations don't have amendment provisions at all. And if you are in a community that does not have an amendment provision in the declaration, it's possible that it requires a unanimous vote of everybody in order to amend that document. And then lastly, as I had mentioned, the rules and regulations almost always simply require board approval, although there are limitations on what they can do. A failure to follow the amendment provisions contained in your documents is going to be can invalidate an amendment. So it's very important that you pay attention to what the amendment process for each of these. Just as a brief background on what each of these documents do. Your articles of incorporation for both the homeowner association setting and the condominium setting, that's the document that describes, this is the way I talk about it when I present to HOAs or associations, is the articles of incorporation deal with the relationship between the corporation and the state of Michigan. It's the state of Michigan recognizing the creation and formation of that nonprofit company. You know, and it's a company like any other. It requires articles of incorporation to be formed. And so it's pretty important that they exist because that's what allows the state to recognize it. In large part, the articles of incorporation have what should be considered relatively non-controversial items. They deal with kind of behind the scenes functioning of the corporation. As part of the amendment process, they're usually the easiest to amend because they don't necessarily affect people on a day-to-day basis, but they do help from a structural standpoint with the corporation itself. The master deed, condo bylaws, and subdivision plan. If you're in a condominium, these are the documents that guide. These are the governing documents regarding the thing that is the condominium, the thing that exists. The subdivision plan is almost never amended unless you're altering what a unit looks like or how limited common elements are allocated. The subdivision plan is almost always left alone because once the condominium is formed, that's the way it is, that's the way it exists, and we generally don't want to touch it. The master deed and condo bylaws, though, the master deed itself is a document that describes the relationship between the condominium as an entity, the condominium thing, and the land. So you're talking about what's a unit, what are the general common elements, what are the limited common elements, what are the responsibilities to maintain those. Those almost always get put into the master deed. The most significant, or what can be the most significant aspect of the master deed deals with who's responsible for what, which we'll get into in a little bit. The condo bylaws, these tend to be the area that are probably of most significance to the individual owners because condo bylaws deal with the relationship between the individual and the condominium. It's going to have restrictions. It's going to have assessment obligations. It's going to have insurance. You know what you're obligated to do by way of insurance. The condo bylaws tend to be pretty significant to people because it tells people what they can and cannot do with their unit, pets, rentals, vehicles, that kind of thing. So whenever you're going about an amendment project, really you need to get that aspect of it right. The declaration of covenants and restrictions is usually very similar to the components of the master deed and condominium bylaws that deal with restrictions. The declaration in most instances is going to be dealing with, again, the relationship between the individual and the land by way of restrictions, what you can and cannot do with your lot, what you can and cannot do by way of use, and what your buildings must or cannot look like. And then lastly, rules and regulations adopted by the board. That deals with means by the board of directors to implement or interpret existing restrictions. I'll get to that a little bit later on, but as you go through the amendment process, rules and regulations really should not be used to impose new restrictions or new obligations. So that's kind of the background. and the setting for the different types of documents that we're looking at when we go through the amendment process. The first one I wanted to touch on is the Articles of Incorporation. This link is here. You could Google it. If you literally typed in Google Michigan Corporation search, you would get to this link. But in case it's useful to you, we've included it here. There are a couple of different portions of the Articles of Incorporation that are significant, and you might not recognize their significance. So I tried to give a couple of different examples of situations where they would be relevant and how they might affect what you can do. And this example here. So we had this fictitious set of characters in Abbey Road condominium, John, Paul, Ringo, and George. And this deals with how a corporation does business. In some instances, corporations are generally presumed to be able to conduct business at meetings. The concept is that you have a quorum requirement, you attend the meeting, and those at the meeting are able to conduct business because of their physical presence. And there have been changes in the law on that approach, some of which now contemplate that you can conduct business in ways without having a meeting. For example, by conducting a vote by ballot. So in this particular situation, and you'll be able to unmute yourselves to answer questions if you like, or you can just submit it via chat. But in this particular instance, let's say that the board of directors wants to respond to somebody and says that the board can go forward with an amendment project without holding a meeting because they've taken a look at the Nonprofit Act and they don't think it's necessary. So they conduct a vote, they don't hold a meeting, and they do it by ballot, even though the bylaws don't necessarily provide for it. And 70% of the people say yes, so that is ordinarily a number that would be able to pass. But if the members did not hold a meeting and instead simply did it by ballot, so one of the questions to you guys on the call is, has that amendment been validly adopted under the circumstances that are described here? If you want to do thumbs up, however you want to vote, if you want to just shout it out, that's okay with me. But I am interested in hearing if you have different views on whether this would be allowed or not. I have no prizes, just so you know. All right, so we have Mike has indicated no, he does not think it's been validly adopted. Beth says yes, because that 70% is a big number. You know, it's a lot of people that are saying yes, it's more than 2/3. In this particular instance, though, Mike is right. An action without meeting provision is a very effective provision that allows you to conduct business in a very efficient way without having to hold a meeting. It was used a lot by communities, by associations during the pandemic when people could not meet. But in the absence of an action without meeting provision in your Articles of Incorporation or bylaws, you cannot do it that way. You need to hold a meeting to do so. So the point of this particular question was to highlight the significance of what seems like a fairly innocuous provision, in action without meeting provision, but it can be very effective. So if you are looking at your documents, one thing to take a look at from an efficiency standpoint is, do we have an action without meeting provision? All right, another example, and still dealing with situations that pertain to the Articles of Incorporation. Sticking with Abbey Road, we have John as the president of the Abbey Road condominium, and he'd really be president of the association. But John is the president. He's on the board with 4 other individuals: Paul, Ringo, George, and Pete Best. And then there's a bonus question at the end related to Pete, but there's 5 of them. And they always have people trying to take pictures of them. It's very annoying to all of them. And John would like to put a fence around the condominium in order to try and keep people out, but the board votes no. John doesn't like it, and he talks to his attorney, Mr. Lee Eastman, although Lee is a music industry attorney. And Lee says, hey, go ahead, you're the president. No, you have the authority to do things in the best interest of the corporation. So you have the authority to do it. John goes ahead and he spends $100,000 of the association's funds to build the fence, to which he derives no specific benefit. The rest of the board members are unhappy and sue him for spending $100,000 on the fence. So in this particular situation, you have a director who has spent a lot of money for the benefit of the community, for which he has not derived a personal benefit. The ultimate question being, is John exposed to the possibility of liability in this particular setting, personal monetary liability for the $100,000 spent? So again, out to the community, I know many of you on the call are members of boards of directors, so this one should probably be close to your heart. But the question is John exposed to liability in this scenario? And if anybody wants to throw out a couple different questions, I'll take a look at chat. Mike says yes, Bet, so I got a bunch of yeses. So in this particular setting, it is possible John is potentially subject to monetary liability in this setting. There are a couple of things that might protect him. For example, he did consult with an attorney. You know, he didn't do this unilaterally. He went to an attorney, albeit a music industry attorney, but an attorney nonetheless. And John did not derive a benefit. So there's a little bit of a situation here that could have been of benefit from a monetary liability standpoint. Under the Nonprofit Corporation Act, the Michigan law now allows a board of directors or an association, excuse me, to limit the personal liability for money damages for individual directors for any aspect, but there are certain things that are not excusable, certain things that you cannot, for which the director will always be liable if they have committed it. And the elements that are not waivable are here. A financial benefit to which they're not entitled. So if John had kept that money, he would not be able to protect himself. If he is an intentional infliction of harm to the corporation, an intentional criminal act, or in a different setting, in certain settings where attorney's fees and costs incurred in a derivative suit, those are non-waivable. In the example that we gave, it's arguable as to whether John would have been able to protect himself from liability if it was adopted. The point of this particular analysis, though, or this series of questions, is that as a director, you do want to look at the limitations of liability provisions in your documents. You may not be going as far as John. You know, there's not necessarily, at least in our example, there's not somebody that would directly contradict the outcome of a vote in that way. That's a pretty extreme example. But there may be situations where you undertake an obligation on behalf of the association that's challenged by others. And in that setting, ideally, you've evaluated the limitations of liability and incorporated some of the amendments that have taken place to minimize your individual exposure to money damages. Now, for the bonus question, why did I have a fifth director? Does anybody, if you can throw out in the chat, are there any theories as to why I had a fifth director in the example that I gave? We had John, Paul, Ringo, George, and Pete Best. So anybody with any takers as to why the fifth director? There's two answers. No one's guessing. Well, the outcome is Pete Best is kind of known as the fifth. Beth is right. That's the actual real answer. But Pete Best was somewhat known as the fifth Beatle. And the reason I put the fifth one in there instead of just the four Beatles that we know is that you do want to have a fifth. You want to have a third, a seventh, a ninth, whatever number you have, you want to make sure that your board can break a tie. We've seen a lot of documents that have a board having the ability to establish between 3 and 7, between 5 and 9, but not requiring an odd number. And although that is usually something saved for the bylaws, I kind of raised it here to highlight the fact that if you have an even number of directors, you want to investigate having an odd number to avoid a tie situation. All right, so that's the Articles of Incorporation. There are a couple of different concepts that are significant to it. Action without meeting provision helps with the functioning of the corporation, and then limitations of liability and indemnification provisions in order to capture changes in the law that took place. All right, so governing documents. In dealing with the governing documents themselves, and primarily talking about your master deed and condo bylaws for a condominium, and then for your HOA, talking about your restrictive covenants, your declaration of restrictions, deed restrictions, however you want to call them. It's the set of documents that are recorded in the chain of title that everybody that's a part of the community has agreed to bind themselves to. Although not part of the amendment process necessarily, there is a significant change in the law that is especially relevant for individuals and communities that are HOAs. At the end of 2018, as part of a lame duck session of our legislature, there was an amendment to the Marketable Record Title Act. What this amendment accomplished was pushed by the title insurance industry. And in essence, what it does is it eliminates restrictive covenants that are not identified by LIBOR and page number and older than 40 years. It risks having a potentially significant impact on communities that were created by developers in the 60s and 70s. I live in one that's created in the 70s, so this is something that potentially has an impact on us too. Because of the significance of its impact, at the end of 2020, there was the effective date of this amendment was taken out to March of 2024. So it's not yet in effect. There are still a couple of years left in which to correct things and possibility for amendment, or to record what's called a claim of interest. The MRTA amendment does permit homeowner associations to record a claim of interest in order to preserve covenants that are older than 40 years. So why do I have this here? One is, if you are in an HOA, you should know about it, especially if your HOA is older than 40 years or close to that the MRTA amendment may have an impact on you. There are, in essence, a couple ways to address it. One way is to go through the filing of a claim of interest process that I described, and that's here. That's specifically provided for under the amendment itself. The other way is, if you are contemplating going through an amendment process, undertaking an amendment of the set of documents, there is a reason to try to complete that prior to March of 2024. Because as long as that's recorded, as long as it relates back by LIBOR and page number to the original set in some way, then you can use that to be able to preserve your existing restrictions and get a new 40-year time period running. So it's something that's very significant, as a potential significant negative effect on communities that are older than 40 years. All right, another reason with respect to condominiums themselves, as you look as to trying to decide, hey, should we engage in the amendment process? Is this something that we should be pursuing? The Michigan Condominium Act was enacted back in 1978. There are actually a fair number of condominiums that exist under the former act, so that were done even before 1978. But 1978 was the date that the Condo Act was done. At a minimum, if your condominium was formed prior to 1978 under the old act, then you, whether it's us or somebody else, you should have those immediately reviewed and amended in order to bring them into compliance with the current act. In addition, there have been amendments to the Condominium Act that have taken place. And basically, if your documents are 20 years old, you should be looking at investigating whether to have those amended or not. In essence, there's one of the main reasons to do it is, yes, there are changes in the law, and a couple of those are here. OTARD rules deal with the over-the-air reception devices, basically SEC rules regarding the use of satellite dishes, but also the society that we have today in 2021, soon to be 2022, is not the society that we have or had back in 2001. Things are different. You know, electric vehicles, solar panels, the use of electronic devices. There's just a lot that's drones. There's just a lot that communities have to deal with now, today, that weren't around when the documents were first drafted. So one of the reasons to pursue an amendment project would be, hey, how old are our documents? When's the last time that we took made a concerted effort to take a look at our documents to see how they look, and do they reflect the community that we want? So age of the document is one of the factors in determining whether you should pursue them or not. So a couple different things. As you take a look at your documents and you're trying to figure out, all right, do we want to change these? Do we need to modify what's in there? What I have up on the screen now is basically a handful of things that you want to keep in mind. You know, what are we looking to correct? What do we want to update? Changes in the law, I mentioned, you know, depending upon how old your documents are, you're going to want to capture the changes in the law, whether they're dealing with substantive issues like satellite dishes that I mentioned, or Fair Housing Act issues related to disability, reasonable accommodations for animals, or those types of things exist. Or you can have changes in efficiency. For example, the Nonprofit Corporation Act. There are changes in the law of the Nonprofit Corporation Act, like the action without meeting provision that I talked about before, that can allow the corporation itself to function in a way that allows more people to participate in a more efficient manner, whether it's through electronic voting, remote communication, or the action without meeting provision. There have been changes in the law that you'll want to capture to maintain efficiency and ensure compliance. And also documents themselves are drafted. Attorneys, we love drafting things, but we're not always perfect. And so the original documents may have conflicting provisions, or they may suffer from legalese. They may be hard to understand or hard to interpret. You may want to simplify the documents, make them easier to understand, or get rid of conflicts that exist between the master deed and the bylaws or within the document itself. So if you have conflicting provisions or provisions that are tough to understand, you may want to think about amending those documents to take care of them. Developer issues. Documents, when they're drafted, documents drafted by the original developer, yes, they are drafted so as to try to attract individuals and have a community that people want to live in, but they're also drafted from the perspective of the developer. They're developer-centric. They're protecting the interests of the developer. They're trying to make sure that the developer has the maximum control that they want in decision-making while they're still around, and also minimizing the liability of the developer as time goes on. And so one of the reasons, especially you would want to pursue an amendment project, would be if the documents that you have in place still reflect the sensibilities of the developer, then you may want to take a look and see if there are provisions that you want to amend in order to shift that focus away from the developer-centric provisions to a lot owner or co-owner type documents. Outdated documents, I've kind of already touched on that. And it's really just updating the documents to reflect the changes that have taken place in society since they were first done. And then maintenance and repair is a big one. As time goes on, you as members of the board of directors get a good feel for who's in the best position to take care of something. Is the lot owner or co-owner in the best position, or is the association? And so, especially if the documents are unclear, or you feel that that allocation should be changed, maintenance and repair responsibilities is an area that you may want to look at to see if it can be updated. So if you have issues in any of those are some of the reasons to pursue a document amendment process. With respect to the developer issues specifically, especially if you have a set of documents that are the draft that you got when you moved in, that the developer put out there initially, especially in condominiums, you've got 4 areas that are of significance. Many developers put in what are called anti-lawsuit provisions. These are designed to make it difficult for the association to pursue the developer in the event that there's a claim. And these are sometimes called sunshine laws, sometimes blue sky provisions. But overall, what these are intended to do is to make it difficult for the association to be able to commence litigation against the developer. And so if your documents still contain that type of provision, that's something that you may want to, or you should consider taking out. The developers also often put assessment exemptions in their documents. Sometimes they'll say they don't pay anything at all. Sometimes only a proportionate share of actual expenses. Sometimes it's simply a factor, a percentage. But oftentimes they'll put in developer assessment exemptions for themselves. And they may put in other development rights, for example, expansion, contraction, or conversion of common elements. These things have a set period of time by which they must take place. And once those times lapse, the association should investigate removing them so no entity stepping in can later claim to have the development rights that the original developer was supposed to have exercised in that in the relevant time period. And I have on here consolidating master deeds, largely because this is an obligation that developers have that they almost never do. The concept being is that once the project is completed, they're supposed to record a consolidating master deed that reflects the community as it was built. And if that has not been done, then you may want to investigate recording a master deed in order to reflect the community as it was actually built. All right, so here we have an example of a developer provision that still exists. So in this particular situation, we have Apple Records being the developer, and let's just say it was poorly built in some capacities. There's numerous leaks. As you can imagine, Apple Records attorney drafted bylaws and have one of the anti-lawsuit provisions requiring 2/3 of co-owners approval for any litigation expenses. The board of directors, controlled by the co-owners, believes that's unenforceable and initiates litigation against the developer related to the leaks. Now, let's just assume that there is clear liability for the leaks that the developer would suffer from. In this particular instance, if Apple Records moves to dismiss the case because the board never got approval of 2/3 of the co-owners in order to incur litigation expenses, who here believes that lawsuit would be dismissed because the anti-lawsuit provision was enforceable? So the outstanding question is that anti-lawsuit provision enforceable, and must the board of directors have gone to the community and obtained a 2/3 vote before commencing litigation? So that's the open question. But what do you guys think? All right, I'll give it a couple seconds. I'll count to 5 internally. 1. All right, I'll take it that everybody's unsure. The answer here is that it is enforceable. In this provision, it would be, although there are certain instances where it's been challenged, but ultimately the Court of Appeals has indicated that it is enforceable. So if your documents have something like this, it is likely something that you should investigate removing. Developers tend to put it in both the articles of incorporation and the bylaws. But it is something that you'll want to investigate taking out if you can, because it is really a developer-centric provision. All right, one of the areas of the amendment process that really should be looked at is deals with provisions in both the bylaws and in the master deed, and that deals with maintenance of the units in the limited common elements from the perspective of from the board of directors. Ideally, you want to have provisions in your bylaws that require co-owners to maintain the things that they're responsible for in a safe, clean, and sanitary condition, and that allows the association to take steps to protect the health, safety, and welfare of the residents. That gives the board of directors the ability to really maintain the association and the condominium itself. And ideally, you would also have in your bylaws illegal activity and noxious activity being prohibited. Those provisions are generally in the bylaws, and they kind of arm the association and the board of directors to make sure that things are kept up, that if lawns are to be maintained, they're maintained a certain way, garbage is maintained in a way that would be improper. Another aspect of maintenance, though, is general maintenance responsibilities. Maintenance responsibilities are usually contained in the master deed, and in the bylaws, there's often a repair and replacement obligations. One of the overarching concepts of an amendment project can be to ensure that there's a coordination between the master deed bylaws of the maintenance obligations, ensuring that the maintenance obligations that exist match the sensibilities of the community as the association and the board of directors has seen it over the years. Usually they're in the best position to evaluate it and see how it should be. All right, just to kind of highlight the significance of the maintenance concept, although with a little bit of a twist focusing on insurance. So here we have an example. We have an individual, Joe Cocker. So he's got a unit, he holds a barbecue, and he burns down Ringo and George's limited common element decks and causes damage to, we'll say, Ringo's priceless art collection within his unit. And there are certain provisions in the bylaws. One, the association is responsible for ensuring all of the common elements. Remember, a deck is a limited common element in this instance. Each co-owner, however, is responsible for repair and replacement of their limited common element deck. So notwithstanding the association's responsibility to ensure, each co-owner is supposed to take care of repair and replacement. And And with respect to the co-owner's obligations for insurance, each co-owner is able to get insurance in the amount that they see fit. So in this situation, let's assume that George has insurance, Ringo and Joe do not. And the overarching question being is what damage is covered by the association's insurance policy. Believe it or not, this issue here is probably in different ways, in different manifestations, is probably the most significant or most common question that we get, whether it's water leaks, whether it's sink repairs, whether it's overflowing plumbing. This type of thing, which is who's responsible for it and who insures it, happens all the time. And the outcome is almost always dictated, is dictated by the documents, sometimes which have differing and conflicting outcomes, and sometimes which have outcomes that are not desired by the community. But in the example that we have, I'll give you kind of how I would have expected it to shake out, although it would be controlled by the documents themselves. Ringo's deck. So even though Ringo, even though each co-owner is responsible for repair and replacement, the association's insurance is probably on the hook for that deck, mainly because Ringo does not have insurance. The association does, and the association would most likely look to it. The association may end up trying to look to the repair and replacement, but ultimately my expectation is that the association's insurance carrier would be responsible for the deck. For Ringo's artwork, this is the tough one. This is personal property. I would hope that there are no sets of documents that would impose an obligation on the association to cover that loss, mainly because the loss would be unquantifiable. However, depending upon the language in your bylaws regarding incidental damage arising from a common element, it is possible that a co-owner may argue that it is damage resulting from a common element, thereby obligating the association. So while I wouldn't expect it, it is possible that the documents could be interpreted that way if there's an incidental damage provision that pushes liability to the association. That type of provision is not entirely uncommon either. And then with respect to George's deck, George does have insurance. I would expect George to be responsible. It should be George and George's insurance carrier that's responsible for that, in large part because he's also supposed to be responsible for repair and replacement. There is a possibility here, though, that if the insurance provision can be interpreted to have the association carrier as being primary and George's carrier as being secondary, then it is possible that the association may also be on the hook in that particular setting also. So notwithstanding the language that pushes responsibility for repair and replacement of the deck to the co-owners, and notwithstanding that it's a co-owner that that caused this, it is possible, depending upon the documents, that the association may be obligated to look to its insurance carrier to make those repairs. All right. One of the areas that I wanted to mention is this is a practical issue more than anything else. One of the things that we've seen come up in our amendment processes is the significance of maintenance, repair, and replacement and insurance to co-owners. As you go through your insurance, through your amendment project, remember that an amendment, in order to pass, needs the approval of a certain number of people within the community. It's going to be, in large part for condominium, it's going to be 2/3. In a HOA, that may be a different threshold, it may be 75%, it may be a majority. But ultimately, if you don't have 2/3 of the community that are buying into what you're trying to do, then it may not work. In the area that we've seen that this is most troublesome, I'll say, just from the perspective of needing to be sure that you get it right as to what the sensibilities of the community are in what you see on the screen now. Co-owners, as you can imagine, are not really fond of buying and getting more responsibility than they believe that they should have. And so the areas that this tends to affect is ordinary maintenance versus repair and replacement. As you look at what your co-owner should be responsible for and what you as the association should be responsible for, if you're pushing more into a co-owner because they're in a better position to take care of those things, what about repair and replacement? In case of a casualty, who do you want to rebuild the unit? And then you have other issues also. As you're coordinating insurance between the co-owner and the association, are you pushing too much to the co-owner, or is it better for the co-owner to insure elements that the co-owner is in the best position to maintain? These are kind of tough questions, and sometimes it will depend upon, one of the factors will be attached condos versus detached condos. As a general rule of thumb, we see detached condos be more comfortable with more liability and more responsibility being on a co-owner, whereas with an attached condo, it's a little more difficult to take that point of view without significant buy-in, because in many instances with attached condos, co-owners tend to, from a mindset, want to preserve that condo, the feel of the association paying for more, being responsible for more. And so if you are going to pursue an amendment project, you need to take that into account, and you need to take into account that you're going to need community support. So this is just intended to be identified as a potential pitfall that can take place in the amendment process if you get it wrong. All right, along these lines, from an amendment standpoint, and this somewhat comes out of the COVID pandemic also, is there are issues related to liability. The amendment process can be used to create limitations on the association's liability or exposure to liability. And I'm not talking about the exposure of an individual director, about the association itself. In essence, the less exposure to liability the association has, the less the premiums for liability insurance the association will have, which is generally a good thing. However, in some instances, you need to be careful about it. And what I've attempted to do here is to identify a couple of instances where you may want to consider amending into your documents limitations on association liability. The first one comes out of a case that was, it's not here in Michigan, but basically there was a camera that was in place. The camera was non-functioning, an individual was attacked, and the individual who was attacked sued the association, alleging that the security camera itself was non-functioning, and therefore the association has breached the duty to maintain the security of the individual. The theory itself was a valid theory, at least in that context. But the ultimate question in this setting would be, do your documents, is the association assuming more liability for security than it would need in that particular instance? And what we would encourage, at least here, is that the association disclaim liability, at least with respect to the security aspect, so that the association is not acting as a guarantor of security within the community. Another example, and this is similar to what I was referencing with respect to the priceless art situation, is incidental damage. So especially in a condominium, you have common elements and you have units. And in many instances, the association is going to be responsible to maintain the general common elements. So the overarching question is, hey, if there is a damage to a unit, if there's damage to the personal property of the individual within the unit, from something that the association was supposed to take care of, is the association responsible for everything that happened? And the example I have in this instance is, you have a general common element, tree limb, so you have a tree that's on the general common elements. During a storm, it goes through a window and allows a significant amount of water to enter that unit. Is the association responsible for all damage to that unit that's ordinarily supposed to be maintained by the co-owner and the personal property of the co-owner? So it is possible that documents can be construed to impose that liability, especially if there's an incidental damage provision that creates liability for the association. What we prefer to see and what we like to see in amendments are to allow the association and the co-owner to be responsible for the things that they're supposed to take care of. And as long as there's no breach, meaning as long as the association did not fail in its responsibility to the co-owner, that the association does not incur the additional liability of also having to pay for everything of the co-owner if there's a damage. One instance where that would not apply necessarily is, let's say the association is aware of a problem. Let's say there's a roof leak that they've been told about that, but they refuse to take action on. If they know about it, if they know they have the responsibility to make that repair and they refuse to do it, in that setting, you would expect the co-owner to be able to look to the association. But in our view, we try to protect the liability of the association so that they're not unnecessarily exposed if they have not done anything wrong. In many documents, at least today, I would push that liability to the association still. There is a, much like the repair and responsibility standpoint, there is a potential amendment pitfall here. If you are going through an amendment project, do keep in mind and try to avoid an us versus them mentality. As the board of directors, one of your responsibilities is to look to the community. You're trying to protect the community and administer the condominium or administer your HOA in the best way possible. If it appears to the community that you are engaging in what I call us versus them, where you are incredibly overprotective of the association and you are pushing too much onto the co-owners in that type of setting, remember, you still need to get to that 2/3 vote in the condo and at least a majority vote elsewhere, usually with respect to HOA documents. But just be careful about making sure that if you are shifting liability, that you have a basis for it and that you can explain why you're doing it to the community. One way to think about it is that the changes that you make in the amendment project should be able to be explained to the community in a way that they can understand and make sense to them. You're looking to reduce the liability exposure of the association, but you're not looking to do that at the expense of the co-owner community. All right, so I wanted to touch on restrictions. So I'm turning now to that's maintenance and repair limitations of liability. I want to touch on some specific provisions that you may see that have come up in documents and specific restrictions. And this particular example can go a couple of different ways. I've chosen a certain way to go about it, but here's the situation. Michigan law, as many of you know, legalizes marijuana in certain settings, including for growing. Federal law, however, still has it as being illegal. So in our particular situation, we have a co-owner, Willie Nelson, within our Abbey Road condominium, who decides to grow a number of plants. The overarching question in this case is, if it is legal under Michigan law, but illegal under federal law, can a neighbor of an individual who is acting in conformity with Michigan law try to force the association to get Willie, in our example, to cease and desist activity that's legal under Michigan law? In this setting, marijuana growing and marijuana usage. Do the bylaws require the association to stop Willie? And then is there a way that the association can free Willie? This is kind of an issue that it's a big issue at the moment. And the main reason is because of that conflict between state law and federal law. Michigan law currently requires under the Condo Act that it prohibits illegal activity, and it requires the board to enforce the condominium bylaws. So it arguably does require the board to take action with respect to stopping Willie because it's illegal under federal law. However, we do recommend that associations adopt a provision that allows the association not to have to take that step. That includes a provision that says along the following lines: illegal activity is prohibited, but a co-owner cannot, but the association itself is not liable if it chooses not to enforce that particular provision, if it's legal under state law. So this is an area that has a potential for controversy. Our provision, the one that we try to recommend, has the association, or give the association the ability to stay out of it if you choose to do so, because of the conflict between state and federal law. Another area in restrictions that is pretty controversial are pets. Pets, vehicles, and rentals are the big three, but there is a provision on pets. So this, depending upon how long you've been on the board of directors, you may have come across this. This is basically a question regarding, are you allowed to have pets or not? So you have an individual, Nicole Ritchie. In essence, she's unhappy, and she feels that a pet chicken will make her feel better. But there's a provision in the bylaws that says household pets, no animals, birds, or poultry shall be kept or maintained except recognized household pets, and no pets for a commercial purpose. Can Nicole Ritchie, have a pet chicken, and what if she had a diagnosis? So this is kind of a little bit of, this is addressing two specific things. One is how well drafted are your documents, meaning that do your pet restrictions preclude what you want? In our situation here, the pet chicken example would be, you would expect it to be prohibited if it was a pet, because it's poultry. So in theory, if it was considered a pet, she cannot have the pet chicken. And no matter what the reason is, you may have a board of directors that takes a look at this provision, sees a clear prohibition of a pet chicken and says, no, Nicole, I'm sorry, you cannot have a chicken in our condominium. But then you have the backup question. What if Nicole had a diagnosis that's really getting to the question of whether or not a chicken would qualify as an emotional support animal? There's two things to keep in mind. One is an animal that qualifies as an emotional support animal is not a pet. So any pet restrictions that exist in the bylaws or anywhere in the governing documents will not apply to an animal that is considered an emotional support animal. At the same time, our example is a pet chicken, which I'd like to think would not be considered an ordinary household pet. And so therefore there's a heightened standard that must be met. So I wouldn't expect Nicole in this example to be able to have the pet chicken qualify as an emotional support animal, but it is possible if she's able to match, get the heightened burden that's necessary for non-household animals. One thing that is potentially problematic on this, though, is what if I were to try and have a Komodo dragon, one of those big Komodo dragons? That in this example here is a little tougher to answer because no animals, what I would try to do if I were the owner of the Komodo dragon is I would try to claim that it was a recognized household pet. I'm not saying that that would be successful or not, but the use of terminology can be harmful sometimes if it opens the door to allow people to have animals that you may not want or may not expect an individual to have. Goats fall in this category, believe it or not. Pigs fall in this category. Those are animals that have often been or sometimes been tried to be recognized as ordinary household pets. All right, so rental issues. This is one of the biggest ones that we have. Many communities are addressing this, not just through their associations, but also through the townships within which they live. In our community, let's say Abbey Road, the Abbey Road bylaws state that units are to be used only for residential use and they prohibit commercial activity, subject to basically home offices. Ringo, however, Ringo is always on tour and he decides to list his unit on an Airbnb to get extra income, although there's no outright prohibition of rentals in this example. In this setting, under these facts, so we have a residential use requirement, we have a commercial activity prohibition, there's no prohibition of rentals. In this setting, is Ringo able to rent his unit on Airbnb? So I will take some questions on this because it's actually coming up a lot. So if you want to drop in chat based on these restrictions only, who thinks that Ringo is able to rent his unit on Airbnb? So Mike says yes. What do you guys think? Is he allowed to do it? So we have one yes. Who's willing to take Mike on? Anybody willing to challenge him and say no? Malcolm, okay, so we have one and two. Okay, so we've got a couple that said no, and we have Mike said yes. So that says no, although home business with yes. So it's back and forth. In this particular setting, I'm somewhat cheating here to a certain extent. It's true there is no prohibition on rentals, but it's going to depend on whether the short-term rental on Airbnb is going to be considered a residential use. Is most likely the outcome. So if it is considered a residential use, then it likely can be used. However, we have had success in it is a common use of a residence. However, the question would be whether or not the use itself is a residential use. We have been able to, on behalf of associations that have challenged it, been able to establish that a short-term rental through Airbnb is usually not going to be considered residential use, especially in the presence of a commercial activity prohibition. And that is generally going to be true if that is the primary or focused use of that property. It's going to be more difficult to prohibit it if the use itself of the home, the primary use is for residential purposes, if the main purpose of the use is for residential use, but there is a only incidental use for short-term rentals, then it may be possible for Ringo to get it through in that case, as long as he's not inadvertently considered commercial activity. We do recommend that there is a specific reference to it, though, in the bylaws, because that argument that I just presented is relying upon the definition of residential use that is currently under attack in the Michigan legislature. Okay, so one of the questions, if every case of commercial use has been consistently applied, that's the other issue, is that, as you can probably imagine, this issue, whether a property can be used for short-term rentals or longer-term rentals, can be applied, is not universally applied in every situation. Boards of directors come and go. People have different sensibilities. Different communities with the same language have different interpretations based upon where they are. So, you know, the point of this particular exercise or this particular review is, right now, there is language out there to support communities that want to limit rentals, and that would be the residential use and commercial activity limitations. But those only go so far. If your community wants to take a particular position on Airbnb, then whether you're for them or against them, you're going to want to take a look at your documents to see what they specifically say, because ultimately the language of the documents should be what controls. If when your documents, they can prohibit rentals. Rentals can be prohibited. They are a use. They are something that can be prohibited it's a matter of contract. But again, however you choose to approach it, remember that you do need to submit it to a vote. And so ultimately you need to make sure that you're matching the sensibilities of the community. Now, the example I gave kind of touched on a number of the concepts that arise out of the short-term rentals, whether or not it's considered a commercial use or not, whether it's a residential use, leasing and rental activity. There's also licensing. Is it a nuisance to others? Is it unlawful activity? Unlawful activity is generally going to mean, is it in compliance with the applicable zoning ordinances, the location that it's at? These are factors that go into it. One of the reasons this is here is that the Michigan legislature just passed, the House did, not the Senate. The Senate has not yet passed it, a HB 4722, which, if it gets to the Senate and if it's passed by the governor, signed by the governor, would severely limit the authority of townships to be able to impose restrictions on short-term rentals in communities. The significance of that being, if your community is relying upon the applicable zoning ordinances to limit your use to residential use only, being a long-term use of more than 30 days, for example, then your community's ability to do that is right now subject to attack, because in essence, the broker lobby, they're just different lobbyists that are promoting short-term rentals and trying to limit the municipality's ability to regulate them through zoning and through definitions of residential use. So if your community has a view of rentals, especially short-term rentals, you should take a look at them, at least make a conscious decision as to whether or not, under what terms do you want to allow them, and what are the prerequisites for being able to do them. Some other standard rental issues. This applies equally to long-term and to short-term, but do you want a rental cap? That kind of goes to what type of community. Do you want an owner-occupied community? Do you want a rental community? If you want an owner-occupied community versus a community of non-owner occupied units, then you may want to think about a rental cap. And what does that rental cap need to be? Especially in a condominium, if you are approaching 1/3 of the units being owned by individuals that are renting, you may find it difficult to pass a rental cap. However, some landlords may view it as great from a monopoly standpoint. But ultimately, the question is, what type of community do you want? And do you want to impose a rental cap? And Michigan law does impose certain obligations with respect to renters. If co-owners are not complying with the documents, not paying assessments, or otherwise not complying with the bylaws, the board of directors does have certain rights vis-a-vis the co-owners and the tenants themselves with respect to rent diversion and also fining and enforcement, as long as the documents provide for it. And then in condominiums, renters are supposed to provide information, are supposed to disclose the fact of renting to the board of directors. In many instances, it's not done, but if it's enforced, it would be done. So there are provisions regarding leasing in the Condominium Act already that are designed to protect communities and at least let the board of directors know what units are being rented. The main point on this particular issue is as you evaluate what you want from renters and what you want through your community, certain tools already exist as long as you know what they are, but you do want to investigate, do your rental provisions match what you want to have out of the community? This one is here mainly because we've actually seen this come up a couple of different ways in a handful of communities. In essence, here's the situation. You have a co-owner. The co-owner is dissatisfied with the, this is probably actually a real link. I didn't think about that. But where you have a community and you have a co-owner is dissatisfied with how it's run, does not get elected to the board. So in order to drum up his own support, he creates his own website or her own website that is intended to mimic that of the actual association and to post information about it and lead people to believe, one, it could be that believes he's that's the real website, or to otherwise post information about it. So the overarching question is, what are the association's options in this respect? A couple things. In theory, even in the absence of an amendment, the association should have the ability, depending upon how that website is being portrayed, to get the individual to stop if they are holding that website out as an attempt to mimic or mislead the public as to what the purpose of the website is. If they are misleading the public as to its genesis, meaning if they're misleading the public into believing that it's the real board of directors website, real association website, then you as the board of directors likely have recourse against that individual. In the absence of that, it may be difficult because they may not be doing anything wrong. What we tend to recommend is that the board of directors, or that the documents include a provision that one, allows the association through the board of directors to control the social media of the association itself and prevent individuals and co-owners from being able to put out competing or alternate websites that attempt to mimic the association. That's not to say that individuals can't have websites or Facebook pages on which topics are discussed, but the overarching question being whether they're holding it out in a way that is an undermining of the proper authority of the association. All right, with respect to enforcement issues, and this goes for both condos and HOAs. If you are a non-condo community, meaning if you have a set of deed restrictions that exist, it's purely a matter of contract. In many instances, especially deed restrictions that were done in the 60s and 70s, those documents don't have a lot of enforcement mechanisms that you see in sort of the modern set of documents. Assessments, how to impose assessments. Are they recordable? Are they able to be imposed as liens? Can you recover attorney's fees? Can you get pre-litigation attorney's fees that you incur as you try to get people to come into compliance without filing a lawsuit? Are you able to impose fines? How do you impose fines? Do you need a hearing or not? And for individuals that don't pay their assessments, can you collect interest or impose late fees? And when are they charged? These issues and topics need to be laid out in your governing documents. We have seen a number of times, especially in a non-condo setting, in a situation where you have an HOA, where in that setting, the community may not have the ability to fine and may not have the ability to collect attorney's fees in the situation of a lawsuit. When those two situations exist, it becomes very difficult monetarily to justify commencing a bylaw enforcement action, because your recourse is to file a lawsuit, but nobody wants to do that because of the cost associated with it, especially if you can't recover your attorney's fees. So as you go through the amendment process, you're going to want to evaluate, hey, from our enforcement mechanisms the way we need them to be, do we have the ability to fine and to bring people into compliance without having a lawsuit? And if we have to go to a lawsuit, are we able to recover our attorney's fees for going through that process? Usually these provisions are spelled out in the condo bylaws, because those are going to track some of the requirements of the Condominium Act. But in the non-condo setting, these issues can really be tricky because they're not always provided for, especially the older the documents. Okay, one of the areas, this is another amendment pitfall that we've seen. So in a lot of instances, the board will decide, we need to adopt these things. We need to get the community in line. We need to, in order to maximize the property values, there are certain things we need to get through. And the three that are that people feel the most are rentals, pets, and vehicles, at least in my experience. And the point of this slide is, as you go through your amendment process, it's one thing to say, this is what we would like the community to do, but ultimately, is that going to be able to be sold to the community? Is the community going to buy into what you're trying to do? So as you go through and amend things, especially in the context of rentals, pets, and vehicles, if restrictions that are sought to be changed are viewed as overly burdensome, then you may have contingents in portions of the community that oppose them or try to undermine your ability to obtain a successful amendment project, even if the bulk of what you're trying to do doesn't relate to the issue that they're concerned about. So in this particular instance, the point is, hey, this is an amendment project. There's a lot that you probably want to do, but be careful in what you're trying to do with the community. With respect to bylaws, there's actually, in the condo bylaws themselves deal with different things. You have restrictions, you have insurance, but you also have the concept of the bylaws that relate to corporate activity and your participation in the corporation itself. One of the reasons to update your bylaws, whether it is the corporate bylaws in the HOA setting or the corporate or the association bylaws in the condo setting, maybe they're tucked at the back of your condominium bylaws. There are certain things that you should evaluate to incorporate from changes that took place in the Nonprofit Corporation Act. And these include participating in meetings by remote communication, voting by electronic means, limitations of director and officer liability that we covered at the very beginning. There have been changes in law regarding inspection of association records, the ability to create executive committees. And these are committees that don't necessarily have to report completely to the board of directors, although they do require a member of the board to be on them. And then especially in the condominium setting, the authority and the ability of an association to opt out of an otherwise mandatory annual audit or review requirement. Each of these things, if your documents and bylaws have not been updated within the past 5 or so years, you're probably not capturing these changes. And part of the reason these changes were made are they help increase the efficiency of the company itself and how it functions and operates. So remote communication. So this is another example I wanted to raise. So John, Paul, and Ringo, hey, these guys are on tour. So they're on tour overseas, as you can probably imagine. But it's time to conduct the annual meeting of the association. They take a look at their condo bylaws, having learned their lesson from the action without meeting experience, but they review the bylaws, and the bylaws do not specifically authorize meeting by remote communication. But although they reviewed them, they didn't exactly learn their lesson. So nonetheless, they schedule a Zoom meeting. They notify all co-owners in advance. They tell everybody how to conduct it by Zoom, and they go ahead with the Zoom meeting. If the bylaws require an annual meeting to take place, is that meeting conducted entirely by remote communication? Is that proper under the Michigan Nonprofit Corporation Act? So that's the question. If you conducted a meeting entirely by Zoom, even if your bylaws do not authorize it, is that permitted under the Act? So yay or nay? I think Mike is cheating. I think Mike's looking at, he must be reading something. So no, Larry says no, Catherine says no. All right, the answer on this one is, it is yes. The act, so Curtis gets it, and Harriet. The answer is yes. So the Michigan Nonprofit Corporation Act actually says that, and this is what I was alluding to with Mike's answer, is that in essence, as long as all participants can both speak and be heard, so that, and not at all times, the board of directors still has the authority to control the conduct of the meeting, but as long as there is a means for people to communicate, then, and as long as the bylaws do not prohibit it, because if the bylaws prohibit it, you can't do it. But as long as the bylaws do not prohibit it, you are able to conduct a meeting entirely or in part by remote communication. It was a tool that we used pretty effectively over the past year and a half or so in order to allow associations to conduct their meetings. You can do it completely by Zoom. You can do it in part by Zoom, such that you have some segments of the community in person. But it's been very effective. If you are going to conduct it, and part of the reason that it's here is that the ideally your documents provide a roadmap to the board of directors as to how to conduct it. Because if you are going to, even though it's in the Nonprofit Corporation Act, not many members of the board of directors actually review the act, so they might not see it. So we do recommend, even though it's in the act, that you include in your bylaws this type of provision so that you can do it by, so that the board knows how to do it by reviewing their documents. So I do have a good question from Andrew about completely by mail. So Andrew, this actually goes right back to the action without meeting provision. If you do, I will not ask if this relates to an annual meeting, and do not tell me. But if you conduct something entirely by mail, that is in essence conducting something using an action without meeting provision, because the concept of an action without meeting is that you do it either by ballot or by mail. If your documents do not permit you to conduct an action without meeting, then it is likely invalid for you to have conducted it that way. Action without meeting requires authority under the bylaws, and meeting by remote communication does not. And the main reason, or one of the reasons for that, is a meeting by remote communication for all practical purposes considered in person. Here's another good question. Electronic communication. So here's how I actually interpret that. I will look at, if we look at it from the perspective of the association communicating to the community. So the association needs to send out a notice. Does the association have the ability to simply email it to everybody? And is email notice sufficient for purposes of notification of a meeting? Does it satisfy the requirements? Under the Nonprofit Corporation Act, email notice is okay as long as the person to whom it's being sent consented to it. If the person that is being sent to did not consent to receive an email notification, then email notice is not proper to that individual, even if your documents provide for it. A co-owner must specifically consent to email notice for that to be allowed. Okay, Catherine asked, can you vote at a, what about voting both at a meeting and electronically? So those are actually two different things. In theory, if you are participating in a meeting by remote communication and you vote during that meeting, you are considered to be voting in person, and you can vote in person, but there are certain things that must be true. One of which is there must be a record of the vote, and the board must be able to have a reasonable basis to determine that the individuals participating in the vote are in fact members and entitled to vote. But even if you say you put your vote in chat, say you clicked on a link and you participated in a vote in that meeting, as long as that vote took place in the context of that meeting by remote communication, that should be considered a vote by an in-person vote. However, let's take another example. Let's say without a meeting, in the absence of a meeting, you email a link to everybody and you ask people to vote electronically without a meeting, that vote, in the absence of an action without meeting provision, and in the absence of a meeting authorizing an electronic vote, that action may be improper because it's not in the context of a meeting. You didn't do it at an in-person meeting, and you didn't do it at a meeting by remote communication. It's the conduct of the meeting itself, whether in person or by remote communication, that authorizes you to be able to take corporate action, meaning to vote. The only alternative to doing it that way would be to use an action without meeting provision, or what's called a polling location. That's actually the topic of a different seminar, which is meetings by remote communication. The main takeaway here, though, is that meetings by remote communication are okay and count as meetings as long as they're done in conformity with the Act and are not prohibited by the bylaws. We recommend, though, that you include a remote communication provision in your bylaws so that the board of directors is aware of their responsibilities. One potential pitfall, another thing I wanted to mention is HOAs versus condos, corporate bylaws versus condominium bylaws. What I've been tending to see a lot is, especially in the HOA setting, meaning a non-condo setting, you have communities that want to put into their corporate bylaws things that belong in their restrictions, rental restrictions, the ability to lien, the ability to impose fines, aspects that don't relate to the corporate world, but that instead relate to the obligation of the individual vis-a-vis their unit, vis-a-vis their lot. There is a fundamental difference between the corporate bylaws, or what's known as association bylaws, and condominium bylaws. If you are amending your corporate bylaws only, corporate bylaws should not be used to impose new restrictions. Corporate bylaws are intended to govern the administration of the corporate entity, meetings, directors, how to vote, what constitutes a member, that type of thing, not necessarily what you can and cannot do with your property. Corporate bylaws are not usually recorded in the Register of Deeds. If they are recorded in the Register of Deeds, that's an undue complication. That's contrasted from condominium bylaws. Condominium bylaws are a creature of statute. They come out of the Condominium Act itself. And in the condominium world, corporate bylaws are often incorporated into the condominium bylaws themselves. I know I think I said the word bylaws about 30 times in that setting, but there is a difference. The corporate bylaws that exist should not be confused with the condominium bylaws that are attached to the master deed in the condo setting. This is usually an issue with homeowner associations, because in many instances, HOAs can easily amend the bylaws. And so they try to tuck different things into the bylaws that really don't belong there, rather than going through an amendment project in the declaration itself. So the big lesson on this one, and the reason this is here, is if you're going through an amendment project, be careful about the difference of corporate bylaws versus condo bylaws, and what you can and cannot do with corporate bylaws. All right, this is my last topic. Last couple of things I wanted to go over. That slide was intended to be a segue to rules and regulations, largely because rules and regulations are adopted by the board of directors, and rules and regulations are intended to interpret or implement existing restrictions. During the coronavirus pandemic, we saw rules and regulations being pretty effective tools to address certain things. For example, using the power for rules and regulations to close common recreational facilities, limiting access to certain general common elements to residents only, collection policies, meaning the using your rulemaking power to you can't outright eliminate somebody's obligation to pay assessments, but allowing the deferral of assessments. So the use of rules and regulations and the policy making authority of the board of directors were pretty significant tools during the pandemic. One of the things that we saw that we have recommended to communities is that they adopt something called emergency powers. This is a concept that we've recommended be put in the powers section of the Articles of Incorporation and in bylaws. The concept being is to clarify that under a state of emergency, during a state of emergency imposed by a governmental entity, the board of directors has the authority to implement rules and regulations which are intended, or adopt rules and regulations which implement things needed to effectuate the state of emergency. So that's something that we've seen that's kind of new, but we are recommending that communities adopt an emergency power section of varying authority depending upon the sensibilities of the community in order to authorize rules and regulations. And one of the main reasons we have that is because the board's rulemaking authority must be anchored in the restrictions themselves. And so we do try to have it so that if you are adopting rules and regulations, you can use it, as I mentioned, to either interpret existing restrictions or implement a restriction that's arising out of your governing documents. And so one of the reasons for the emergency power section is to ensure there's no question that the board has that power in that setting. This is just an example of certain areas that we found it's beneficial to have rules and regulations. Aesthetic issues that can be architectural, what things look like, choice of stain for decks, paint color options, fences, height of fences, color of fences, types of fences, sheds, those types of things. Architectural rules can be very helpful to guide the community. Bylaw enforcement policy, code of ethics for the board members themselves, potentially confidentiality, also dealing with contractors can fit in that category. And then collection policies, fair housing policy, and that's usually dealing with a request for reasonable accommodation. Maybe somebody wants to put a ramp in front of their house, somebody going back to the emotional support animal concept. A written policy can help guide the board of directors in making sure that they don't take a wrong step in evaluating a request from a co-owner. Some of these instances are not required. For example, you're not necessarily obligated to have in your governing documents a provision regarding emotional support animals or reasonable accommodations. And the reason you're not required to have them is because they exist independently of your documents. But what we like to see is that the board can look to its documents to know what they can and cannot do. So even if you're not obligated to have these provisions in your documents, oftentimes it's helpful to have them in there so you don't end up incurring liability unnecessarily. All right, so here's an example of a whether it's a proper adoption of a rule and regulation. So you have the association bylaws that require the association to repair and replace limited common element front door of each unit. Bylaws also permit the board to adopt rules regarding the appearance of the condominium. John, who's on the board of directors, along with Ringo and Paul, they adopt a rule requiring that all front doors be painted brown, as you see here. Jim Morrison, however, our pal Jim, he refuses to paint the doors brown and instead paints his psychedelic colors. So is the rule that the board, that the door is required to be brown, is that enforceable? That is a limited common element door that is used only by Jim Morrison and his, we'll say, entourage. Is that particular rule enforceable, yay or nay? Mike says yes. Yes, yes. T, Andrew's thirsty. All right, so this setting, this one's kind of easy because it's psychedelic. It's from a standpoint, you would hope that the association has the ability to say no. So in that setting, we know at least that he'd be able to prevent it from being painted a psychedelic color. And in that setting, I would expect that the brown would be enforceable. So let's take it another step. Let's say that Jim is like, okay, white is a common, what if he paints it white? If Jim paints his door white, not a bad color, a non-color really. If he paints it white, is that problematic? Is the board able to enforce its rule against Jim if Jim paints it white? Yes, so it really, I'm cheating again. It really should be the same analysis, whether it's the psychedelic colors, which are easy to contest and easy to control and easy to see why the association has that authority, versus white, which may be more difficult. In this situation, what the board of directors is doing is it's using a rule to implement its existing responsibility and authority to regulate the outside appearance of the condominium. Ultimately, requiring doors be brown is an implementation of an existing restriction. You've heard me use the terms implement and interpret a few times. Much like bylaws, where corporate bylaws can be used to impose things that go beyond what should be allowed. In many instances, or some instances, boards may try to use rules and regulations. Dark brown versus light brown is a good question. It depends on how closely it's done. That is a possible ambiguity. And you can see now how Jim may have an argument on that one. That's actually, at least in the facts that I gave, there's no answer. I didn't provide enough to be able to decide dark brown versus light brown. Rules should not be used and cannot be used to impose new burdens on owners. If rules cannot be anchored in existing restrictions, if you cannot relate your rule back to an existing obligation, then under Michigan law, that rule and those regulations are potentially subject to challenge as being non-enforceable. As an example, let's say your bylaws, your condominium bylaws, nor your declaration in HOA prohibit pools. And somebody wants to put a pool in and the board says, no, we don't allow pools in this community. We have a rule against it. See, our rule has been around for 20 years. If that prohibition is not contained in your restrictions or not contained in condominium bylaws, it is likely that the board does not have the authority to adopt it. So I have this on here as a potential pitfall. As you go through and adopt rules and regulations, they are incredibly helpful in guiding the community and interpreting existing restrictions and in implementing existing restrictions and obligations, but they cannot be used to impose new burdens. All right, that's what I have. I want to end with rules and regulations. If you're muted and you have questions, or if you simply want to drop it in chat, that's fine. But at least for the next portion of it, I will open it up to you guys if you have any questions.
Yes, I have a question.
Sure, go ahead. Is that Curtis?
Yes.
Go ahead, Curtis.
Yeah, at my condominium, we're in the process of amending our documents. And we had a set of bylaws under the master deed and a set of bylaws under the Articles of Incorporation. And we presented the two restatements of those documents, and the co-owners approved the new Articles of Incorporation, but did not approve the new master deed.
Right.
However, under those two documents, we did not include bylaws under the new Articles of Incorporation. All of the bylaws were incorporated into one, and that was attached to the master deed.
Right.
So our new set of bylaws was not passed.
Right.
Now, when we voted for the new Articles of Incorporation, did we also lose those bylaws that were attached to the Articles of Incorporation?
Well, the Articles of Incorporation were a standalone document. That the Articles of Incorporation actually did not have any bylaws attached to them. They will be independent and stand by on their own. With a condominium, the condo bylaws and master deed go together, or tend to go together. And if they did not pass, then the condo bylaws would not have passed either. For the Articles of Incorporation, though, those would have passed and they would exist having been filed with the state, but they don't have a bylaws portion with them.
Okay, but that leaves us now with only one document, but that document, the one that's attached to our master deed, does not have any information in about our annual meeting or the composition of our board of directors, because that was all described and documented in the bylaws that were attached to the old articles of incorporation.
So those corporate bylaws, which are what they would be, I would actually not have expect those corporate bylaws to have gone away. Usually the corporate bylaws, and Curtis, we can talk about this later too, but I would expect the corporate bylaws, the articles of incorporation would be replaced. And so the old articles would be replaced with the new articles. The corporate bylaws that exist, along with the condominium bylaws and master deed, if they did not pass, would still exist in their current form. And so if the condo bylaws didn't pass, then I would expect that the corporate bylaws that existed previously, the old ones, I would expect to still be in effect.
Okay, thank you.
Yep.
Thank you.
No problem. Thanks for the question, Curtis. Okay, so Andrew asked, we cannot do an annual meeting completely by mail. It really depends on your documents. An annual meeting is supposed to be in person. There's a couple different reasons for that. One of which is there's financial information that's supposed to be shared, and then the election of directors is ordinarily supposed to be done at an annual meeting. Whether it is true in your case would need somebody to take a look at your bylaws to see what they say needs to be done, whether you have an action without meeting provision. But it is true that my expectation is that the obligation of an association to conduct an annual meeting itself cannot usually be abdicated by doing a vote simply by mail, especially in the absence of an action without meeting provision. Can a board do a vote by email for something which comes up in the course of the month? So boards have a little more flexibility. They still have an action without meeting provision requirement if you're going to conduct business outside of a meeting. But remember, a meeting by remote communication is ordinarily allowed. And so if you conduct a meeting by telephone, if you conduct a meeting by Zoom, that type of thing can be done. And in some instances, you can do you can conduct business by consent. So consent is different than voting by ballot. If you have individuals, if you have the board of directors, if everybody consents to conducting certain business, then you likely I would expect you to be able to do that by email. However, again, this is a general expectation, and a definitive answer to your question, Beth, would need to be, you need to look at the corporate bylaws section of yours to see what the obligations are for the conduct of board business. But ordinarily, it's usually easier for a board to conduct day-to-day or month-to-month business in the course of a month. Okay, so Malcolm asks, when voting on new documents, is it on each, do you do it as one thumbs up or thumbs down, or do you do an article by separate votes? You can do either or. We tend to prefer that it's done in a way that it's a thumbs up or thumbs down as much as possible. In some instances, if you have extremely controversial provisions, you may want to call those out separately and have a thumbs up or thumbs down on those specific things. But in general, most communities pursue a thumbs up or thumbs down on as a whole, on the whole set, as opposed to doing a specific article. But you can do it by article. And when that's done, it's usually done because there are controversial provisions that are going different ways that the board just doesn't know if it's hitting the sensibilities of the community the right way. All right, anybody else? All right, well, I'll stop sharing. I want to thank you all for participating and listening. Hopefully it was informative. If you have questions, please feel free to email me. The recording, I think they're going to put this up on our website. So there will be a link that will be put in place of the link that was there. There will be a link that will be put to get you to the recording. It takes a while for it to download, and we have a marketing representative who will do that for us.
Thank you.
All right. Thanks, everybody. Have a good night.